Hi, this is Bob Brennan. It's June 30th, 2010. I'm going to give a little talk today about your rights, your consumer protection rights in California as far as dealing with debt collectors goes. Now, the key thing to know about the California debt collection law, the debt collection law that protects consumers, the key thing to know about the California debt collection law is it not only applies to debt collectors, but it also applies to the original creditors. The federal debt collection law for consumers only applies to debt collectors, people who are actually collecting the debts and they own or they take an assignment of the debts from the original creditors. In California, if the original creditors harass you or try to intimidate you or lie to you in collecting the debt, you have basically the full rights of the federal law against the original creditors. You don't have that under the federal law. Under the California law, you have protection against the original creditors, also against the debt collectors. So good place, good time to be in California because more and more credit card companies and major department stores and things like that are hiring their own in-house debt collectors, and they have to basically observe the same law as debt collectors do when they are collecting debts. Now, a lot of my clients and a lot of potential clients ask me what exactly is debt collection harassment, and the answer here is a couple key points or a couple key principles you need to know. Number one is debt collectors are allowed to contact you to collect a debt. They are allowed to contact you in a civilized manner at reasonable times in a reasonable manner in an effort to persuade you to repay the debt. They are allowed to do that by law. However, they are not allowed to harass or intimidate you or lie to you, basically. Those are, I would say, the three broad categories: harassment, intimidation, or lying in collecting the debt. And so that's in very broad terms what debt collectors are allowed to do or what they're not allowed to do. Some examples of debt collection abuse which we've handled: they're not allowed to use profanity when they speak with you. They're not allowed to call you repeatedly, like if they call you once, twice in an evening during normal hours, let's say between 6 o'clock and 8:30 or something like that. They're allowed to do that. They're not allowed to call you 17 times in that same period of time, basically trying to get you to go crazy or repay the debt. They're not allowed to contact you at unusual times. Basically, they're allowed to contact you during business hours up until, say, about 9 o'clock in the evening. They're not allowed to call you at 4:30 in the morning or 11 o'clock at night. They're not allowed to lie to you. They cannot tell you that they're from the sheriff's department or that you're going to go to jail if you don't repay the debt. These are lies. In general, the worst that's going to happen to you if you don't repay a debt is there's going to be a judgment taken out against you, and they could garnish your wages and things like that, but you will not be going to jail. They're not allowed to tell you that, for instance, they're from the federal government or something like that in an effort to collect the debt. If they're a private debt collector, they have to tell you who they are. They have to tell you who they represent when they contact you. They have to write a letter to you before they start the debt collection calls. These are the types of things that they are obligated to do. If they don't do these things, or if they start harassing you, trying to intimidate you, threatening you with physical violence, that type of thing, those are examples of debt collection abuse. Another big area of debt collection abuse that we see quite a bit of is contacting third parties. Before a debt collector has a judgment against you, they're allowed to contact third parties, but only to find out your location information. They cannot contact a third party, say a coworker or your boss or a family member, and say, well, Mary Smith is a deadbeat and she owes us a bunch of money. We want to contact her. Do you know where she is? That type of thing. In short, they would be slandering you if they did that. They're not allowed to do that. They are allowed to call your boss or allowed to call your neighbors and say, does Mary Smith live at 123 Jones Street? They're allowed to ask that question, and they're supposed to stop there. They're not allowed to get into the fact that they're a debt collector, that you allegedly owe a debt, those types of things. So keep an eye on the third party abuse, which happens quite often in debt collection circumstances. There are many, many types of debt collection abuse. I've written a pretty exhaustive article on it, a pretty complete article. Debt collection abuse is only limited by the imagination of the debt collector. So it would be impossible for me to cover each and every form of debt collection abuse of which I've heard. But if you go to my website, it's called www.socaldebtcollectionabuse.com. www.socal, S-O-C-A-L, like Southern California, debtcollectionabuse.com, all one word. If you go to that website, there's a pretty exhaustive article on the different types of debt collection abuse you may find. And like another area where we do a lot of work, false credit reporting, If a debt collector is falsely credit reporting you, that is another form of debt collection abuse, and you would have rights not only under the debt collection protection laws, but also under the credit reporting laws as well. Now, there's two more things I want to talk about, and that is number one, what are your damages under a Debt Collection Act? A lot of people come in and they think that if there's been debt collection abuse that it wipes out the debt. It doesn't. The debt is still there, and the debt still has to be dealt with if it's a valid debt. But you can get basically all your actual damages, including your emotional distress damages, and you can get a penalty of $1,000 per violation for willful violations of the debt collection laws. So that's an additional penalty of $1,000 that you can get on top of your actual damages, which includes your emotional distress damages. The other thing you need to know is that under the debt collection laws, the debt collector or the creditor would pay your attorney's fees. So, let's say my firm would have attorney's fees on your behalf. If we win the case, we would get those fees from the debt collector or from the creditor. We would not actually be charging you for those attorney's fees. So this allows us to take most of these cases on a contingency or on a semi-contingency basis. So those are the general things you need to know about the debt collection laws. Now let me tell you the key to success or failure in these cases. The key to success or failure is how well you document the debt collection abuse or what independent evidence you have of the debt collection abuse. If someone comes into my office and says a debt collector called on the phone 17 times and used profanity and threatened to arrest me if I didn't pay the debt, if they have no witnesses, if they have not recorded the phone conversation, if they have no documents showing that happened, a lot of times I got to tell them that I cannot help them. If it's just going to be the consumer's word versus the debt collector, it's going to be a tough case. The debt collectors are very careful to document all of their conversations and so forth, and so a lot of times the consumer is going to lose those cases. You have to have independent witnesses, you have to have documentation, you have to have tape recordings of the debt collection abuse before you have a case where I can look you in the eye and tell you that you're going to win. On tape recordings, what I always tell my clients to do is to send a certified letter to the debt collector telling them you're going to tape record. Don't tell them on the phone, but send them a letter. Obviously, you would keep a copy, telling them that you're going to be recording the conversations, and after you've sent that letter, then record all the conversations from the debt collector, because at that point, you want to basically gather evidence that they're abusing you in trying to collect the debt. Third-party independent witnesses. If you have co-workers or family members who can come in and testify about the debt collection abuse, that's going to help your case. But where these cases can stumble and where they can be losing cases is where people come in and they want to just put their testimony and nothing more up against the debt collector's testimony, and I got to tell you, that's not a good case. If you want to win these cases, if you want to pursue these cases, you need to have independent evidence and independent witnesses or tape recordings to show that the abuse occurred. One more thing, and that is on the topic of negotiating in these cases. A lot of times, if someone has a debt and there's been debt collection abuse, in the course of negotiating settlements, that's the type of thing that will often come out in the negotiations. In short, the creditor will modify or eliminate the debt that the consumer owes in exchange for a settlement of the case and maybe some money and some attorney's fees on top of it. So these are all things that are part of the negotiations. That, in brief, in very brief, is the California Debt Collection Abuse Law. And again, there's a lot more information on my website, www.SoCal Debt Collection Abuse, one word, SoCalDebtCollectionAbuse.com. I hope this has been helpful, and I hope you're having a great summer. Take care.